All rise. Court of Appeals Division 1 is now in session.
Thank you. Be seated. Too much paper here. Good morning. Now is the time set for oral argument in cause number 1 CACV 150534. And I'm going to pronounce it Boruch. Is there a better way to do that?
I pronounce it Boruch.
Boruch, thank you. Mary C. Boruch versus the State of Arizona et al. How's that? For your information, for everyone's information, these proceedings are being both audio and video recorded, so barring any unforeseen problems, we get to be YouTube stars in a few days. Counsel, each side will be entitled to the normal 20 minutes. We would ask that you respect that time period. The timer located on the podium will let you know how much time you have left. And for the appellant's benefit, if you wish to reserve any portion of your 20 minutes for rebuttal, please let us know. We will make a little effort to keep from using up all your time for you. However, ultimately, your reserving of rebuttal time will be up to you. We've reviewed the briefs and conferenced the case this morning, so we are well aware of the facts and the issues attendant to the argument. You might want to both keep that in mind just so you can figure out how you want to construct your best use of time. Counsel, when you come to the podium, I would ask that you state your name and who you represent. And with that, counsel, you can begin.
May it please the court. My name is Keith Hendricks. I represent the plaintiffs in this case. They are too numerous to list. I will note that there are representatives of the plaintiffs in the court with us here today. There are three issues that we have presented for the court. First, that the trial court erred in granting the motion to dismiss the consideration of an injunction against the City of Mesa and the State of Arizona Department of Transportation. Second, that the court erred in refusing to grant leave to amend on the basis of futility. And third, that the court erred in refusing to grant a Rule 60 relief and entered a improper form of judgment that was neither litigated nor stipulated to by the parties. I will note that reversing on the first issue really makes the other two issues moot. We don't even need to reach them if we reverse on the first issue. Likewise, reversing on the second issue would make the third issue moot. The third issue only becomes relevant if reversal is denied on the first three. This appeal, at its core, is about whether a court can even consider an injunction against the City of Mesa and the Department of Arizona to prevent them from using the plaintiff's homes as the overflow for a drainage area that comprises 20 square miles of the city and miles of US 60. Whether they can take all of that water and concentrate it, if you will, into a spigot and point it at the plaintiff's home and then say, yeah, but we get to decide that. The court can't even consider whether or not this is an appropriate action. The court ruled that...
Hendricks, let me ask you a question about this. Based on the allegations in the complaint, it appears that we had this incredible storm in September. And we know, and I've read your the complaint very closely, and so the water, the channel, the flooding, Emerald Park wasn't quite to capacity, and yet the pumping continued on.
Yes.
This was a world-class storm. For those of us who've lived in Arizona a long time, we're always told about the 100-year flood that happens every year. But nevertheless, this appears to have been the first time this had happened. Does that make a difference here in assessing whether the prohibitions against injunctive relief apply?
I'm glad you asked that question. Can I do a housekeeping? I would like to reserve 5 minutes. I apologize for not bringing that up front.
Too late now.
Well, in that case, Judge Norris, that is an excellent question, and it really, I think, is a fundamental misconception in the case. It was a big storm, But we are not seeking to enjoin the actions in that storm. They happened. They occurred. We are not seeking to enjoin the city from what happened in 2014. We are seeking to enjoin the city from doing it the next time. And they're here fighting, saying we have the right to do it again. And that is the whole question before the court. When they say, can we continue to pump water into people's homes after the flood is over, when they have the capacity to store it upstream, when they have the capacity to send it downstream, but they want to intentionally continue to divert and pump into the people's homes? That is the question that we are presenting. Not whether they did it before, whether they know. They are on notice now.
So you're asking for an injunction against the practice or policy?
Yes, we're asking the court to, what we want the trial court, and the way we described it, is enjoin them from using Emerald Park or using the neighborhood adjacent to Emerald Park as the overflow. In other words, if you fill up Emerald Park, you can't continue to pump upstream when you have capacity to hold it upstream. You can't continue to divert water from the channel when you have the capacity to send it downstream. You can't unilaterally decide that the overflow for Emerald Park is my client's neighborhoods. That's what we're asking the court to enjoin. We're not saying tell the court how to do their job. We're just saying you can't intentionally continue to divert water into Emerald Park when you're overflowing it and you have the capacity to do other actions. And that is what we think that the allegations in the complaint are, and we believe very strongly that the trial court's decision of the law in this matter cannot be reconciled with the case law, the Williams, the Ziegler, the Marston cases that show when courts can instruct governmental agencies and enjoin them. And that's where I think the analysis needs to go. Unless you have any other questions, that's where I'd like to head the discussion next, is the analysis of those three and many of the other cases.
Counsel, if you can do us, I think, a quick favor, starting out, 12-1802 is addressed fairly roundly, I think, in the course of this case. What is the actual statutory entitlement that they're being denied through the issuance of the injunction?
I'm sorry, I don't understand the question, Your Honor.
Am I missing something? Go ahead with your question and let me reformulate that.
Okay. I'll think about that, but let me go through what I believe is the most important case. I'm going to start with the Williams case, because I do not believe that you can reconcile the trial court's decision in this case with the holding in the Williams case. If you'll recall, the Williams case is where the Arizona National Guard was using the city of Tucson's International Airport for training exercises. And in the case, it is very explicit that there is no allegation that there was any violation of any federal regulations. The National Guard had the right to do that. They weren't violating any rule or regulation in deciding to use the airport as a training base. But there was an elementary school a mile off at the end of the runway. And every time they take those big military jets, it was, quote, deafening and interrupting. And it was alleged to be a public nuisance. And so there was a lawsuit brought to enjoin the National Guard from doing what they had the right to do, use the airport as a training base. And they had the right to set the times conditions. There is no allegation that they violated any rule. It's just the application of that created a public nuisance. The trial court dismissed it and said, 1802, I can't tell another form of government. In this case, the National Guard. You got federal issues. You've got military issues. You got major weight on the other side. And then the trial court said, I can't tell them how to do their job. And the Supreme Court, in a 4-1 decision, 3 joined the original opinion, 1 wrote a special concurrence, and Judge Holohan wrote a dissent that was overruled. But the dissent, I think, is very critical here, because the dissent argues exactly what the trial court in this case found. That was rejected.
Let me add, we've all read the Williams case closely. One can argue that in Williams, the state was acting intentionally. Because after all, you don't get into a jet and fly a jet negligently, at least we hope you don't. So, and that the continued conduct was an intentional decision to keep flying over the school, thus causing the disruption of the school. Here we have a flood, and the complaint in very broad brush argues or alleges that it was basically negligence operation of the channel and the Emerald Park and the continued dumping in of the water. But the flavor is different. The facts are different. It's not an ongoing, constant problem. Does that make a difference here with application of the statute?
First, I don't think it does make a determinative difference, but second, I would beg to differ with that characterization of the complaint. That allegation of negligent conduct is cherry-picked because there are no fewer than 15 or 20 allegations of intentional conduct. We talked about it. They intentionally continued to pump after the storm had stopped, after there was capacity
but
upstream.
my point is a little bit different. Does it matter?
Yeah, well,
I mean, let's say, for example, that a government entity in this state operates city-owned property, operates city-owned property, and it's just negligent, and it creates a nuisance that if we operated it, we'd be sued by our neighbors for creating a nuisance. Versus intent. Does it matter for purposes of this statute at all?
I don't believe it does, and I believe the answer to that can be seen in the Ziegler and the Marston cases. And also when you take the Williams case in. There is no discussion in Williams as to whether or not the conduct was intentional or negligent, whether or not the timing, there was something. It was, the allegation was they are doing an action that creates a public nuisance. And to the extent that it is a public nuisance, it becomes unreasonable and outside of the scope of their authority. There is no allegation of intent.
If I may, Judge Norris's question was, there's no dispute in Williams that it was intentional conduct.
Okay.
So there's no reason for them to discuss.
So let's discuss the Ziegler and the Marston cases, which I think would then, and I get the distinction there, I do, but in Ziegler, that you have the Department of Arizona access, they create, and the statute, they cited in the case, that the state had the responsibility to design a contract. And it says, that the statute says the administration shall establish and operate a program for inpatient hospital reimbursement. They quoted that in the case. So the department has the obligation, the intent to create the program. The allegation in there is they created a program that was so onerous that nobody could meet it. But now the question is on this intent question. And the allegation here is they have the obligation to do the act, they have the obligation to do what they're supposed to do, but it was being done in an unreasonable way. And again, in Ziegler, if you employed an intent requirement that says that the intent was that it be unreasonable, there's no discussion there. It just says if it turns out to be unreasonable, then the court can enjoin it. And they reversed a motion to dismiss on this argument saying we can't tell another branch of government how to do its job. And they came back and said, yes, you can if they're doing it unreasonably. No discussion of intent. And I would submit that if you imposed an intent requirement like the judge did here, Ziegler would not be decided the way it was. And Marston also. In Marston, the county recorder, political parties nominated the registrar. The county recorder appointed them. They had the authority. And the statute specifically said that could be refused for just cause. And so the county recorder had the option, had the discretion, had the authority to decide if they were not qualified to do the job. The county recorder decided to implement that by creating a test. And they said the test was unreasonable. And the court agreed. Now, if we had an intent requirement in there, I would submit Marston could not have been decided the way it was. You have here the issue of the courts coming in and saying, yes, you have the obligation to do your job, but if you exceed it, if you do it unreasonably, if you create a public nuisance in doing your job, courts can and should enjoin you. And that is what we are alleging here. That creating a system, they had the right to create the system. They have the right to operate it. But when they intentionally continue to pump and divert water at my client's property after the rain stopped and they have other options available to them, that is something where the courts get involved.
Well, I would think then your answer to the questions would just simply be, we don't need to get into that distinction because there was intentional conduct here.
I believe that my argument is twofold. First, the court was absolutely wrong when they said we did not allege intentional conduct. We did. I can give you paragraph numbers if you would like them for the record, where we allege specific intentional conduct. And then number two, they misapplied the law. You can't square that ruling with those cases. So from a factual standpoint, we didn't allege intent. From a law standpoint, intent has never been found as an element by any court, and it would be inconsistent with the holdings of some prior decisions. So I think from both on a factual and a legal basis, intent is the wrong analysis.
Would the state be entitled to do what it did here? And what I'm meaning to get to is along the line of what Judge North started with, the 100-year flood issue. Is the state required to maintain circumstances that are going to be adequate under all circumstances? Or is this a case of they pick their poison? And if they don't create something that's adequate, it's simply an issue of damages. Is that where we're at?
Well, in the first place, that would be an issue that you'd have a trial on at the trial court to define what would be an acceptable injunction. In this case, where you say you have capacity upstream, you have capacity downstream, you didn't need to continue to divert the water into the neighborhood, the court could say in those situations you're enjoined from doing it, and would not need to tell the court the agency how to do its business. But that would be something that would be based on the facts and why we should have been allowed to move forward with discovery to determine what the exigencies and what the permeations of the injunction can and should be. I want to very quickly go to the other two issues, and then we'll get it. The other two issues, the motion to amend, there are a good 15 additional allegations in the motion to amend where we allege intentional conduct. But essentially, the court said, you cannot allege intentional conduct because I find, as a matter of law, that this can't be intentional. Well, that doesn't make sense. Intent is a fact question. We alleged, and those allegations should have been accepted as true. The final point I want to make is one that really I get to the fundamental inequity of this case. We really got whipsawed. They came to the trial court and said, this case has nothing to do with damages. It's only about an injunction. Dismiss the case. It's not going to hurt at all their damages case. And then they submitted a form of judgment that dismissed our damages case with prejudice. We stipulated that that's not what was going to be entered. We stipulated, we had conversations, and that stipulated judgment was given to the court. Now, whether it be through error or he says intentional, he said, I approve and, I accept the stipulated judgment that was lodged to make it clear damages were not being dismissed. And then he went ahead and entered a form of judgment that dismissed all claims with prejudice. Then the very same parties who said this case has nothing to do with damages came back, and our clients, the 93 clients who got their homes destroyed, their lives turned up down, they got the case thrown out because res judicata. Your damages case has been dismissed with prejudice. It's just fundamentally inequitable, unfair, and should not be countenanced. And if there's nothing else, I'd like to reserve the rest of my time.
Thank you, Counsel.
May it please the court, Doug Northup. I represent the state of Arizona. Lori Vopel is here with me representing the city of Mesa. I'll be making the argument today, but she's available, obviously, to answer any questions you all may have of her. The plaintiffs agree that ADOT and the city have both the duty and the responsibility for providing drainage in connection with the US 60 freeway project. They agree with that.
Does that mean they automatically have the right or the responsibility to drain that onto private property?
They have the authority, and is alleged in the complaint, you have to deal with the drainage. There's a series of retention basins. And as Mr. Hendricks said at the argument on the motion to dismiss below, the injunction says you can't overflow Emerald Park Basin. We're not saying you can't put it into Emerald Park Basin. And Judge Warner says, well, does it say what the city is supposed to do with the water to prevent it from overflowing the basin? And Mr. Hendricks says, well, there's many things they can do. You can't come up here and tell them what they can do. What you can do is tell them what they can't do, and what they can't do is they can't pump the water off the freeway into our backyards. There is no question, and the focus that the court respectfully needs to focus on and address is dealing with the drainage, creating this system, something that is within the lawful authority of the state of Arizona and the city of Mesa, and it is.
Well, let's drill down to that a little bit. There is no question, based on my reading of all the authorities you've cited, that the city and the state are certainly lawfully entitled to and responsible for the management of stormwater. There's just no question about it. And I think the question I have, however, does that give the city and the state the right to, arguably or allegedly, exercise that authority in such a way that damages 93 or all the plaintiffs' homes and inundates their homes with water so that they were negligent in the operation of that? And I don't see any exception that allows a city or a state to basically operate and create a public nuisance. I really don't.
The question, though, is, in this particular circumstance, this thing was designed over 30 years ago. There was a massive flood.
I was young then,
If it wasn't designed properly, or they don't like how it was run on this day, they would have damage claims.
I'm not talking about damage.
The
I want to
question
talk
is
about
injunction.
Injunctive relief, that they can continue to use these people's homes as basically truly the terminal retention basis.
Well, but again, the question is, this is part of a series, as alleged in the complaint, of retention basins and a channel.
Right.
Right? And in the circumstance on this particular storm, water overflowed. But the question is, and is in the Valencia case that we cited, and that wasn't a 1802 case specifically, but the question was dealing with the authority of the state. And the Supreme Court said the act of issuing a certificate, something the Corporation Commission was authorized to do by statute, did not become authorized simply because the act was performed erroneously.
Let me give you a hypothetical. I've been thinking a lot about this case. The city and the state are authorized to operate our roads and our highway system. And let's say that the city and the state decide that they want to encourage public transit. So what they do is they say, okay, we're going to allow by every bus stop in the city, we're going to encourage food trucks and buskers to go out there and play, and we're really going to do it at night because we want to have kind of a strong, vibrant urban core. So at every bus stop in the state, you have food trucks and you have buskers and you have music, and it goes on all night. Okay, so the city and the state are operating within their lawful authority to have a transit system, to encourage public transit and public ridership. But they're doing it in a way that will disturb the surrounding homeowners and the people who live right next to the bus stops. And you're telling me then that under Arizona law, a court cannot enjoin the creation of a public nuisance by a municipality or by the state?
There's a question there, I think, under your hypothetical, whether they have gone outside their lawful powers.
No. That's not my hypothetical. My hypothetical is that the city and the state are authorized. Let's assume there's a statute out there and there's an ordinance that authorizes the city and the state to operate a transit system to encourage ridership, and that is what they have done. And they operate it in such a way as to create a public nuisance or some type of damage to the surrounding neighborhood. Tell me what authority would bar a court from enjoining that type of activity?
Your Honor, if you are saying, the problem I'm struggling with your hypothetical is, I think what you've said in parking food trucks and having music in that you have gone outside the authority that they would have.
Okay, let's assume then that they're city-owned food trucks and they're city-owned musicians or city-sponsored musicians because they want, so they're subcontractors of the city. So they're being operated by the city, okay? Let's change the hypothetical. Then, in that situation, does the statute bar the homeowners from obtaining injunctive relief?
In that circumstance, and you use the word nuisance.
Okay.
In that circumstance, nuisance is an intentional tort. And what you're talking about is intentionally doing acts in that circumstance. So again.
But haven't the plaintiffs alleged that here in paragraph 151 of the complaint? They say defendants have and appear to intend to continue to concentrate and divert water into Emerald Park without providing for such measures, and the measures are so the water can go elsewhere, either downstream or somewhere else, except in the homeowners, for such measures and appropriate overflow relief. So haven't they alleged that The first time may have been forgivable. That was an accident. That was perhaps negligence. But they're alleging that the city and the state are going to continue doing it.
They did not, nor could they allege that there was an intention to flood their property.
But they're alleging that going into the future, that there is an ongoing intent to continue to concentrate and divert water into Emerald Park without providing for such measures and appropriate overflow relief. So they have alleged that here, and this is on a motion to dismiss. And don't they have a right to at least get into the courtroom to ask the court to determine what's gone on here, what's going to go on here, and whether there is, in fact, a city and state-created ongoing danger of a nuisance and continued damage to these people's homes?
No. And let me call your attention, Your Honor, to the Taft versus Ball case. The court there said a canal builder on summary judgment could not be liable for trespass because it did not intend to flood adjacent land. There was no allegation, nor could there be, that there was an intention on the state or the city's part to flood anything.
That's not an Arizona case.
Yes, it is. Absolutely, Your Honor. It's 169 Arizona,
yeah.
173 at page 176. We've also cited the Mine versus Cook case for the same proposition. And just by throwing around words like intentional and unlawful does not get you there.
So is your point that even though the statute does not use the word intent, that somehow 12-1802 were to read into the terms of that statute the word it has to be intentional?
No. I think that we're focusing in your hypothetical, with all respect, on the wrong inquiry.
Okay.
I think the inquiry is, the act that's here is operating a drainage system that's been operated the same way for 30 years. Does the state become the guarantor of every storm that hits? And did it act in creating, the state and the city, this drainage system and operating it within its lawful authority?
That's the
Absolutely
past. We're talking
did.
about the future. We're talking about the future.
Same
That's what
question.
they've alleged.
Same question. The question is, if the way they've operated and we have another massive, massive storm that ends up with overflowing, they have a damages remedy. In the case before Judge Gerlach, they have alleged an taking
The fact
and a
that they have a
damages claim.
damage remedy is, in my view, in another case, and besides the point. We are talking about injunctive relief to bar or to prohibit the city and the state from continuing to use the neighborhoods and the homes as basically the dumping ground for all this water. And the question is, they may well have a damage claim. I have no opinion on that. That's not an issue that we have to address. The issue is whether the city and the state can, now that they're clearly on notice that there's a serious problem here, can they continue to use the homeowner's property?
Well, first of all, Your Honor, two things. Under the statute, the anti-injunction statutes, the courts have said you have to show they acted outside their lawful authority, and they do not have an adequate remedy at law. And
on the adequate remedy of law, that is not an argument that was raised in the Superior Court. So in my view, it's waived. So let's go back to the issues that really have been addressed here. How then do you explain away, for example, the statement by our Supreme Court in Williams about, for example, I think it's the Williams case, excuse me, maybe one of the tax cases, it's Wales, in which the court said an injunction is an appropriate remedy to determine whether rights have been or will be affected by the arbitrary or unreasonable action of an administrative officer or agent. If there is an abuse of discretionary power, the judiciary has the power to restrain the same.
which case is that, Your Honor?
That's the Wales versus State Tax Commission case.
Well, I don't think that was an 1802 case, Your Honor. And I think that some of those cases were impliedly overruled by the Valencia case that I read from earlier. But again, you have to go back to, were they acting lawfully? Again, they're saying you not only have the duty but the responsibility to address the drainage here. We just don't like how you did it. And think about what they're asking in terms of the injunction.
If I may, I thought the complaint alleged that they knowingly continued to pump when the retention basin was full.
I don't believe that's what they said. I mean, they said that the storm, the water stopped hours before there was overflowing, and the Emerald Basin continued to to rise. And again, this whole area, parts of Mesa, drains into these series of retention basins and the channels. But again, there's no allegation that they said, well, let's turn pumps A on so we'll overflow Emerald Basin instead of somewhere else. There could be no allegation of that, and there wasn't. And that's the whole problem. What would the injunction look like here? You're going to ask, they're asking the trial court to come in and say, okay, ADOT, you can't run the pumps on the 60 because that might overflow Emerald Basin. Well, what about the person who gets in a wreck on Highway 60? And then the court is suddenly being asked, and that's why this is so important, it's a separation of powers principle. The court is being asked to substitute its judgment for the engineers.
You know, all that may well be the case. And it may well be, if this were to go to trial, that a court would find, we cannot give you the injunction that you have asked for all of these reasons. But this is an issue about whether they get to go walk through the courtroom and stay in the courtroom to have that fight for a later day. It may well be that the court cannot, or it will shape an injunction that is different than what they are requesting. But the issue is whether they get to go into the courthouse. And you're making an argument that, well, we can't tell how a court would shape an injunction, therefore they don't have even a right to ask for injunctive relief.
That's not the point I was making, Your Honor. The point I was making is why 1802 reads the way that it does, that the courts can't issue an injunction to prevent public enforcement of public statutes by officers or the exercise of public or private office in a lawful manner. How they run the system involves discretionary acts of the people who are in the best position to do that, the engineers for ADOT and the city of Mesa.
So this is just a question of damages. You're saying you can damage property at any time, and it's just a case of how much you have to pay out for the damage caused to these people's property by the overfilling of the next Emerald Park.
In this circumstance, if in fact that is the case, that is their remedy. The court coming in and saying, yes, ADOT and city, you have the authority. It's your job, in fact, to deal with these drainage issues, but we're going to tell you how to do that job. And what happens if Emerald Basin, something is done so Emerald Park doesn't overflow, but one of the other basins does, and now that person is suing. And they're coming in and saying, no, you should pump it back in Emerald Basin, or you should pump it to one of the other ones upstream. That's the problem. It puts the courts in the position of telling the engineers how to do their job. And if
so does that mean then the engineers get to be negligent? They get a free pass?
If they are negligent.
So they are negligent and they get a free pass and the courts can do nothing?
Absolutely not. If they are negligent, if they commit torts or violations of the law or whatever that would give rise to damages claims, that's your remedy. There's an allegation here. By using this as what they call an overflow, that's a taking.
Here's the problem I have. I think there may well be a taking, but look, the homeowner's property has been damaged. They may well have a damage claim. What then do they do when they want to turn around and sell their home? And Mr. and Mrs. Smith want to sell the home. They have to disclose to the buyer, you know, we don't really live in a floodplain, but we really do because the city and the state are using our property for overflow from Emerald Park. So it has diminished their value of their property.
That's exactly
right?
what damages
right.
for takings
going
compensate.
To go on an ongoing basis, and you're saying, well, it was because an engineer made that decision. It's okay, and it's immunized from judicial.
It's not immunized. It is immunized from an injunction under the circumstances of this case. And if, in fact, the evidence were that this were likely to happen again, it may be a permanent taking, it may be a complete taking. Those are all things that are compensable. But to come in and say to the city and the state, you have to run this system that's been just fine for 30 years, by the way, but you have to run it differently because of a storm that's been described as a 1,000-year storm, and even based on plaintiff's complaint was one of unprecedented nature, that you have to suddenly start doing something differently without giving consequence. This isn't just about Emerald Basin. The US 60 runs for miles. This channel runs for miles. This was a system that was designed with, according to their own allegations, with a series of retention basins. And if we focus on Emerald Basin, we are now going to be affecting other people, and every one of of those people are going to say, wait a minute, you can't do that to me. That's the reason it's a separation of powers issue. And Judge Norris, you're exactly right to be concerned about, can they just get off scot-free? Absolutely not. They brought damages claims. Those are proceeding. There are some issues as to certain plaintiffs, but they've alleged trespass and nuisance and all kinds of things. And if they can prove those claims in a taking, they will get damages for the full amount of their harm. But they're asking this court to insert itself in an area where the legislature has made very clear that that is not what courts do. And if we had an allegation that you did something unlawfully, but as the exchange I showed with Mr. Hendricks, they're saying, oh, it's okay to use the system. In fact, you have to. And it's okay to use Emerald Basin. In fact, you have to. Just don't use it in a way that overflows. And that's my point as to what would an injunction ever look like. And what happens then when they say, you didn't turn the pumps on fast enough on the 60 because you were worried about Emerald Basin and somebody got killed in a car wreck? What happens upstream? That's my point. And that's what's so important. The key question here is it a question of you couldn't do it, you couldn't run your system, or you should have done it differently or better? And there's not one of the cases that the plaintiffs cite to you that would support the notion. The Williams case, for example, Ziegler was a case where the access director was accused of vetoing and blocking county eligibility determinations outside his authority. The Marston case involved allegations of the county recorder doing things and imposing testing requirements they did not have authority to do. And counsel did not, in their complaint or their amended complaint, suggest that the state and the city did not have authority to design and maintain and operate a drainage system as part of the US 60, and we've cited you the statutes and the law saying they had to do that. And if the consequence of that is that somebody was harmed and they have a damage remedy, so be it. If the answer is Mother Nature cannot be predicted or controlled, the state doesn't become the guarantor of everything that happens, then so be it. But it doesn't authorize this court to enter an injunction. I'd like to address briefly, I want to make sure I've answered all the questions, the Rule 60 point, because that's an important one as well. There was no damages claim alleged in this case at all, and it wasn't raised below, and it wasn't raised in the Court of Appeals issues or briefing here. In fact, in the responses below, I'd like the court to look at footnote 4 on page 11, where the plaintiffs say, in arguing that the complaint didn't state a damages claim, plaintiffs are in the process of preparing notices of claims and reserve the right to seek leave to amend their complaint. And Judge Warner made it clear the judgment that was submitted did not have Rule 54C language in it. It was not a proper judgment. There was no stipulation. There was no agreement. The parties intended to end this case completely, as evidenced further by the fact that the plaintiffs filed their separate damages lawsuit the very day that Judge Warner signed the judgment in this case. So the argument, not only was that argument waived, but it's demonstrably false. This is a circumstance, Your Honor, where there is no authority that would allow the court to enter an injunction below. We think that Judge Warner properly dismissed the claims, that he denied the motion to amend, and he denied the Rule 60 motion properly. I would be happy to answer any further questions you have, but I think I'm about out of time.
Thanks, counsel. Mr. Hendrickson, you're starting. Am I incorrect that that there's an allegation that the state was advised as to what was taking place at Emerald Park and chose not to do anything to try and prevent the water or redirect the water away from Emerald Park?
Yes, there is specifically an allegation.
And excuse me, but I just thought I heard that there's no way of showing that, in fact, knowing the damage that was being done, that they didn't do everything they could to prevent it from continuing.
Paragraph 129 of the complaint, the city requested permission from ADOT to pump the water out of the park into the channel, sending it downstream, and ADOT refused.
Now, would that be a relief of the pressure on the Emerald Park facility, the Emerald Park retention area?
Yes. The allegation is during the crisis, as the water was coming up, the mayor calls the ADOT, or somebody in his office calls ADOT. And this is on the news. It's in the press. And they called ADOT and said, "Let us pump the water out of Emerald Park and back into the channel." And mayor says that ADOT refused that request.
So the election was, rather than turning it into the balance of the channel that would have taken the water elsewhere, it was to use the folks outside Emerald Park's properties as a dumping area for this water.
Exactly. And that is...
Is that then, if you will please, now we get to go back to my very first question, which was 12-1802. Then are we restricting them, preventing them from exercising their responsibilities under statute?
No more than Williams...
Did they have an outlet that would have avoided the damages?
No.
Could they have pumped it down the channel?
Yeah, they could have brought in pumps and pumped it down the channel, which they asked permission to do. And according to the news reports, ADOT said, no, you can't do that. So they could have brought in temporary relief and brought in pumps and started pumping as the water got to the top. It's also alleged in the complaint. This is not the first time they've come close to overtopping the park. It's the only time it did overtop, but they've filled up Emerald Park in other, much less storms, within a few feet of the top many times.
Would an injunction violate 12-1802, 4 or 6?
No. Under the applications of the Williams case, the Ziegler case, the Marston case, where it is arbitrary, where the quote that Judge Norris read, where it says that the judiciary can stop the executive or the legislative branches from doing things that are arbitrary. And that's under the facts of this case, where we're alleging there was capacity upstream. They didn't need to open the gates upstream and have the water rush downstream. I call this the big flush. They hold the water for 4 hours, and then they open up all the gates upstream at the same time, pushing it all down. There was no reason that they had to do that.
Doesn't that go to Mr. Northrop's argument is that you're actually asking the courts to be engineers at that point in time?
No.
Whether it was a valid reason or not a valid reason to open up those upstream gates?
No more than in the Williams case, where you're asking the courts to tell the National Guard when they can fly so that they don't create a public nuisance. The courts have the right. If that argument, if the authority to do the act were the sole question, Judge Holohan's dissent in Williams would be the law. But that is one dissent. 4 justices voted against that. Judge Holohan clearly said the only inquiry is, do they have the authority to do that? That is the position that you just heard from my good friend Mr. Northup. That the only inquiry is, do they have the authority to do that? That's what Judge Holohan said in his dissent. And he said, we shouldn't have people do that. But the majority, the law in this state is not that the authority to do the act is the sole inquiry. And so with that, the final point I wanted to make is his argument, well, they have the damages claim. Under the rulings of this court, 93 plaintiffs do not have a damages claim. They were dismissed with all claims with prejudice by virtue of the judgment that the court entered. It was not stipulated to. The parties had reached stipulations and submitted a stipulated form of judgment. The court had bifurcated damages. If you go back and you look at the case, there were the motion to dismiss brought 3 issues, and one of them was damages. And the court bifurcated it and held that in abeyance.
Give me, which one was the damage issue?
Their argument was they can't bring a claim because they haven't alleged damages. And we responded, right. We have alleged damages, and that would be a motion for summary judgment, and we need to have discovery on it. And the court bifurcated issues B and C, which were damages, and frankly, I forget the other one, damages were the important one, said we're going to hold those in abeyance. We're going to rule on injunction. But the allegation is in the prayer for relief, we didn't pray for money damages, but we did allege in the complaint that we had been damaged and that we would, and we reserved the right. And he bifurcated that issue and held it on abeyance. And then he issued an order dismissing all claims.
So effectively, the assertion, the position of the court was that because you could not obtain an objection, you could not, because you could not obtain an injunction, you could not obtain damages?
Well, the argument in the original motion to dismiss is because you did not allege damages, you have no claim for relief. And so dismiss this because they have no claim for relief. We responded, we have alleged millions of dollars of damages, and we're entitled to amend, and that would be a summary judgment motion because they included facts outside the issue. They stipulated to that. It was bifurcated and put off for judgment until the end of July. The court said, I'm not even going to consider the damages issue until the end of July. Then he ruled on the injunction case and said, that's the only thing in the prayer for relief, so I'm dismissing, quote, all claims. Then the dismissal with prejudice gets the whipsaw event. So he entered a judgment that was inconsistent with the facts of the case, He entered it was not those cases, the damages were never litigated, and they were never stipulated to that they should be dismissed. He simply did it sua sponte without even telling us the form of judgment. The parties negotiated a form of judgment that would have made this clear, so I wouldn't have the problem in the second case. The judge ignored that, said all claims are dismissed with prejudice, and then the next judge down the case said, well, you're 93 plaintiffs, so sad, too bad, you're out. So, anyway, my time is up unless you have any further questions.
Thank you. We do have a reason for asking or for conducting oral argument, and I think you've seen it today. Counsel, thank you for your argument. Thank you for the direction you've given us. We're going to take the matter under advisement at this time, and we will rule in due course. So thank you.
Thank you.
We're adjourned.